Well, I think we'll go ahead and get started. Again, my name is Steve Huth. I'm the Career and Technical Education Coordinator for the Janesville School District. And you met Susie Dantuma. Please use her as a resource. I'm very pleased to also have Jim Ciolino. Jim is the Director of Labor Standards Bureau at DWD's Equal Rights Division and ERD's Assistant Administrators at Equal Rights Division.
Yep, correct.
And Joy Gonder is an independent risk management consultant whose firm does not sell insurance. Does not sell insurance. She has worked with the Wisconsin school districts for over 20 years, and I first met her about 20 years ago when I was on a school board. So it's interesting that she's still doing this work, and she's a fabulous resource for our school districts. She is representing the WASB, which is Wisconsin Association of School Boards Insurance Plan, and is available to any WASB member or CISA personnel to address insurance and risk management questions. We're going to start with the first question that the young lady asked in the back, and Jim is going to take that question and Susie and what that means for the youth apprenticeship student. So Jim, repeat that question for us, would you?
If I remember correctly, the question was whether minors under the age of 18 who are usually unable to work on certain pieces of equipment, if they would be downgraded in their youth apprenticeship. And the real answer to that question is that there are some exceptions for students working in youth apprenticeship programs. So there are, in the child labor laws, federal law and state law are pretty similar. There are exclusions, there are exceptions, there are prohibitions on certain types of equipment usually, and some places of employment. 16 and 17-year-old kids can work in manufacturing, generally speaking, but there are certain pieces of equipment they can't use. However, then there's an exception that in the law that says student learners, if they meet certain criteria, can use those pieces of equipment if they're using those pieces of equipment for short periods, intermittent, that it's under a program, a written student learner agreement, which is exactly what the youth apprenticeship program is. They can use those otherwise prohibited pieces of equipment. There still are some pieces of equipment that they can never use, and those are outlined in the child labor rules, and I can talk to you about those, but they tend to be the most hazardous pieces, like working with explosives, for example, working with hoists. Now, there are some hoists that they can use anyway, so there are a lot of exceptions built into the laws, but it's really the most dangerous, logging, mining, those kinds of things that they can never do even in a youth apprenticeship program. So the real answer to that is ask us if you've got a question about a particular piece of equipment. Generally, they can do that, and I know the youth apprenticeship programs are set up in a way that there isn't something that's going to be prohibited to keep the minors from doing the work.
So Jim, would it be safe to say that if they were to go into child labor law rules and they would do a search under student learner, that would be the place that they could talk to their insurance agent or whoever to address what a student learner is? Because it's buried a little bit in the child labor laws. It's like 50 pages in or something, I think.
It is kind of buried, but it's DWD 270.14 sub 3, and I have copies of the child labor code that I can give to interested people, and I can point it out to you. But it is really specific what a student learner is and how they get that exemption from the otherwise prohibited work.
What is the maximum number of hours a student can work? Some of those laws did change. So can someone address the maximum number of hours a student can work now?
Yeah, that's me again. 16 and 17-year-olds are no longer limited in the number of hours they can work. And that's inside youth apprenticeship programs or outside of youth apprenticeship programs. There's no limit on the number of hours that 16 and 17-year-old kids can work. If they're younger, there are stricter limits on the hours they can work because we went to federal law as of July 1st of 2011. So there's not a difference any longer between state and federal law.
And previously that was, I believe, 26 hours. Is that correct?
That's right.
So that is a significant change, and it's important that you note that. And refresh for me, I'm trying to remember what the hours are that a student can start and end work, a student learner.
We don't set that.
Really?
No, so for 16, 17-year-olds, There's no limit on the number of hours or time of day they can work. There are two, I guess, exceptions to that rule. There's always an exception. They can't work during hours they're supposed to be in school. That makes sense. And then if they work past 11 o'clock one night, they have to have at least 8 hours of rest before they start work the next day.
As a follow-up to that, Susie, could you talk about any of the students that you have working in youth apprenticeship that actually start early in the day?
We do have several students that set up their schedules based on when their employers need them and set up their school day based on that. And so we do have students that start working at 6 in the morning and work from 6 until 10 and then attend their high school later in the day to complete their graduation requirements. We have some students that are attending classes out here at Blackhawk as high school students, starting at 6 in the morning 2 days a week. So they'll come 6 until 11 here to Blackhawk 2 days a week. The other 3 days a week, then they go to work from 6 until 11 and then attend high school in the afternoon. We have other students who have set up their schedules so that they leave school at 1:30, 2 o'clock, and go to work or to class at that point. So really the student works with their guidance counselor to set up their school day so that they can work when you, the employer, need them to work.
Joy, a question for you. Are there any businesses that have an active insurance policy that does not cover employees either over the age or under the age of 18?
This is not characterized in the context of a specific kind of insurance policy, so I'm going to make my response as broad as possible. So we're talking about workers' compensation or automobile liability or general liability, and the short answer is no. That when an insurance policy is written for any of your businesses, for example, there is not an exclusion or a condition in the policy that says if the person involved in the claim, whether it's an injury to that person or they do something and somebody else gets injured, that coverage is a function of the age of the individual. So for example, youth apprenticeship participants, in the eyes of the insurance world, that individual is just like any of your other employees. Okay.
So everyone needs to carry workman's comp insurance for?
Well, everyone according to the statute, because there are exceptions, as Jim noted, there are exceptions for certain firms that are not required to carry workers' compensation insurance, and it usually is for smaller, very small businesses and potentially farmers as well.
As a follow-up, one of the questions that was submitted is who's responsible or liable if a student is in an auto accident while traveling from school to work or from work back to school during school hours or as part of one of these programs?
Okay, so as Susie was mentioning, you have students that will go directly from home to the work site and then go from there to their high school, or they might go from home to high school and then to the job site. Typically, for really any of us, when a person is en route from their home to work or to the job site, if there is an accident and they suffer injuries, typically they have to rely, the injured party has to rely on their own health insurance. And that applies usually regardless of whether it's a student, a 16, 17-year-old, or any one of us. There, again, are exceptions, and that the exceptions focus in on whether or not they're, getting paid, so to speak, while they're driving. For example, when I'm driving from here back to my office, if I get into an accident, that's workers' compensation, because it's different. Normally I go from my home to my office. But in most circumstances, again, somebody's injured either on the way to the job site from the high school or from the job site back to the high school. If they're injured, it's not workers' compensation. That injured party would have to rely on, their health insurance.
Does that help answer that? Okay, great. In the event a student needs to be terminated, and I think, Susie, you could talk about the process we use for youth apprenticeship and for internships. If they need to be terminated for cause, what is the process that should be followed?
Well, for youth apprenticeship, if they need to be terminated, and they're not really risking anyone, if there's anything going on that they need to be terminated immediately, terminate them immediately. If it's something that you have some time, you give them mornings, that sort of stuff, we'd like to be involved with the process to help make that a learning experience for them. And we do go through and kind of write things up and make sure that they know that they're being removed from the situation, make sure that they have the information about why they're being removed from that position, and share with their parents that they've been removed and why they're being removed, to really try to make that a learning experience so that when they go into the next job that they aren't doing those same things that had them removed from this position. So that's really what we're asking for, is don't do anything that's not safe. So remove someone that's doing something unsafe. But if you have, someone who's showing up late for work or things like that you've talked to, that you have an opportunity to really help them learn from, we'd like to be involved with the process so that we can talk to them about that and share it with their parents.
Joy?
Yeah, I was just going to add, you heard both Susie and Carrie mention during their presentation the use of a written agreement. And in your packet, there's a handout that I put together, and you'll see, and this was totally not coordinated between me and Susie and Carrie, but you'll see that the very first thing that I say is make sure that you use a written agreement, whether it's youth apprenticeship or any other kind of school to work, job shadow program. From a risk management perspective, what I have found, and maybe you have experienced, is that problems arise when there is misunderstandings and misinformation. So in the instance of terminating somebody from a youth apprenticeship program, you might actually want to consider including in that written agreement the process that might be followed if termination has to occur. Because again, this is one of keeping everybody as informed as possible. And so for any business that haven't previously had a youth apprenticeship program or even a job shadow or something like that, I definitely recommend using a written agreement. Now, there are all kinds of agreements out there. I have talked to countless youth apprenticeship coordinators and other individuals that are responsible for setting up these opportunities for students. And my firm can help you in conjunction with the school district that you're working with to ensure that those agreements address as many questions that might come up in the future. And I guess the other thing that I would add is Steve mentioned that I'm available to school districts and CESAs, and I'm available on a complimentary basis because whether it's Janesville or Beloit or Albany, their youth coordinator or youth apprenticeship people can call me, and it's at no charge. I also work with chamber people. So your chambers in your various areas, they'll call me and they'll say, well, we want to set up this program, but we just don't really know how to do it, or they have a question about insurance or liability. So I work with chamber people too. The whole point of all of our efforts is to provide you a workforce, an up-and-coming workforce, and provide those students with an opportunity.
And I would reinforce this written agreement thing because if you don't have a written school-to-work agreement, you can't take advantage of those exceptions from the child labor rules. That's one of the requirements of being a student learner, whether it's a youth apprenticeship or any other kind of student learner program.
When would a student be eligible for unemployment?
I guess I'll field that one. It may have changed. I worked in the unemployment insurance division many years ago, and at one point, student work could be excluded from the wages that that could be used to earn unemployment. That may have changed. On the other hand, they also have to be eligible for unemployment benefits. They have to be available for full-time first shift work, which is really hard for students who are required to attend school till they're 18. But maybe after they're 18, they might be eligible.
We actually just had this situation with a part-time staff person personally, and what was most critical is to make sure that you have the training agreement, that you document that you have warnings, working with Susie or working with Carrie in the internship program so that it's just not a immediate termination without cause is very important. And as Susie said, we're trying to create a learning environment for students who we want to be successful, who have shown an interest in being successful. So we tend to go that way, but it's really important. The unemployment office told me that it's very important that the documents were in line, which was in our favor.
And you may know that you have to prove misconduct if you're going to deny somebody's unemployment. That's under current law. The law, in my understanding, is changing so that there will be also a firing for cause exclusion from unemployment benefits. So I don't have the details on that yet, but it should go into effect at the beginning of January. So it's going to be less than proving misconduct to deny benefits.
As long as you have your mic up, Jim, can youth apprenticeships or minors operate company-supplied vehicles? And if yes, when would that be?
It's difficult for minors of any age to be driving as a regular part of their job. 16 and under, never on public roads. If they're not on public roads, it's fine if they're 16 or 17 and have a license. But if they have to travel on a highway, they have to be at least 17. It has to be, there are very strict provisions in the child labor rules, and there's no exception for student learners in this case. But for 17-year-olds, they have to have safety instruction. You have to actually go out there and show them how to use the seat belt and any other safety equipment that's in a vehicle. They have to have a license, a non-probationary license, and they can only drive during daytime hours, no passengers, not a regular part of their job. It's incredibly limited.
And what about forklifts?
Well, forklifts are hoists, so generally they can't be operated as part of even part of a youth apprenticeship. There are some exclusions for, and I should say this, pallet jacks that you don't raise beyond like 6 inches, I believe it is. There are all these exclusions from that. So don't let the use of a hoist bother you, but forklift is not going to be acceptable unless they're keeping it very low to the ground just to move pallets across a shop.
Okay, thank you. A question from the field. Healthcare is a large, growing employment sector. Are there special rules related to students working in a healthcare-related setting?
Healthcare-related settings there aren't any special rules other than there is a provision in federal law has been pretty lax on this, and so have we, about the person lifts. If you're lifting patients, you have to be very careful about how you do that. And I would have to find the particular federal bulletin about that to give you the details. But that's the only thing I can think of. You can't be involved in actual patient care if you're under 18, but supporting and other things like that you can do.
Can you add to that, Susie? That special memo that was like 2 years ago, I think, for Hoyer lifts, is that right?
Yes. It basically says that a minor, needs to be working with someone else, so they cannot be the sole person using a person lift, is my understanding. And so they would have to have another adult with them whenever they would need to be using that piece of equipment. So that's my understanding of how that one works. I have the bulletin. If you're interested in it, I can certainly share it with you. Just let me know after the event today.
Another thing that came up was how do we deal with confidentiality? So I'd have any one of the panel members take that.
Well, what I would recommend is you should treat these students as you would any other employee when it comes to informing them and educating them about the absolute need to maintain confidentiality of any kind of sensitive information. Depending on the purpose for which the student is placed, he or she may or may not, either have access or have occasion to see proprietary or personally identifiable information But if they are, or if you think they may be, I would recommend from a liability perspective and preventing, situations where, a student sees certain kind of information or data, that you give them proper training, number one, in terms of, what proprietary or personal information is, what they can and cannot do with it, and you may even want to go so far as to, implement procedures and protocols so that you do everything you can to, set up a firewall, if you will. I'm not suggesting that students would, use the information or actively seek it out, but from your perspective, I'm taught, and I tell my clients, think of the worst case scenario. So the worst case scenario would be that some proprietary information, whether it's health related, social security number, gets released or becomes publicly available. So you're faced with, or the community employer is faced with an angry family or individual. And so you have to be able to defend, so to speak, what occurred, why it occurred. So the more procedures that you can put in place up front to avoid the release or the access, so it's never released, hopefully, you're going to be better off. So again, I would treat those students certainly as I would any other employee relative to maintaining confidentiality.
Thank you. It has proven very effective as we've worked with healthcare providers. The healthcare providers have had the students sign a confidentiality agreement, the same one that the employers use with their regular employees. We've trained, I believe, in the last 20 years, probably 400 students in the nursing program through this program. And over that time, because I've been doing this for 20 years, we only have had one student terminated for breach of confidentiality. So we take it very seriously. If Susie were contacted that there were a concern, she would be there immediately, and the students take it very seriously. That's true for any company. There are many companies we work with that have patents, that have very proprietary rights, and it's important that the students respect that. The question is paid versus non-paid interns, and interns would be over 18. What are the FLSA laws? What are FLSA laws? What does it stand for?
FLSA is the Fair Labor Standards
Thank
Act,
you.
and that's the federal law. In Wisconsin, we enforce just our various rules. We have laws on overtime, minimum wage, and there are bulletins that have been out under the Fair Labor Standards Act for many years that deal with paid versus unpaid internships. So the first disclaimer is I don't enforce the Fair Labor Standards Act. And under Wisconsin law, if you want to volunteer, if you're over the age of 18 to work for nothing, you can do that. But the minute you pay somebody anything for the work they perform, then they are employees and entitled to minimum wage. Federal law is different on that. So the federal law does not like it when for-profit entities use unpaid employees. And they've come down on people recently, but the rules have been in place for 30 years probably. You hear about it as though it's a new thing, but it isn't. There are 6 criteria that have to be met for somebody to be in an unpaid internship under the Fair Labor Standards Act. And what I would do, when you go back to your office, if you're interested in this, Google FLSA unpaid internship, and you'll get those 6 criteria. And it's pretty limited. You know, they want the young people to not be doing any work that benefits you, really. So it has to be something that is just observing, or they may do some hands-on work every now and then, but there's a paid employee with them at all times, so there's really no benefit to your enterprise at all, except that maybe someday when this person is done with the unpaid internship, they might be able to step in and do work for you.
And the criteria for the below 18 student learner, is it still true that a student cannot displace a full-time employee?
Yeah, that's correct. Students can't replace paid employees. also in Wisconsin, minors can't volunteer, so you can't have unpaid minors employed by you, except for if you're a nonprofit organization. That's the only area where they can volunteer. And then there are strict criteria. The parents have to give permission. They can't work they can't volunteer in a capacity that they wouldn't be able to be employed in, those sorts of things. And also with the youth apprenticeship, that's a separate program, but they can never replace paid employees even if they're volunteering. So that's something you have to keep in mind.
So the follow-up question is, and I'll have to elaborate a little, if they meet that criteria for an unpaid internship and they read that standard and they still want to have an unpaid intern and the unpaid intern gets hurt, who's liable?
Okay, so is this person, what age? We don't know.
This would be an unpaid intern who would be liable if that intern is injured at the work site.
Okay, so the answer, and I was talking earlier during breakfast, talking to Mr. Eckert, and I said, well, you're probably going to hear a definite maybe, well, it depends. And so I would say the answer to that question is it depends. And what I mean by that is, to me, the word internship can be interpreted fairly generically. I'm going to focus in on the unpaid aspect of it. And typically when somebody is injured in a workplace, okay, and they are not somebody that's just coming into your plant or your offices as a visitor, okay, but they're behind the scenes, so to speak, on the floor. If they are injured and they are not being paid, then there are 3 questions that are going to be asked to address who's responsible for the injuries, the medical expenses. One is who was controlling the activities at the time of the injury. And this is in order of importance. So control is the biggest issue. The second question is an economic benefit being derived, in this case, by the worksite employer? Okay, so if you have somebody that is just merely job shadowing, so they're literally looking over the shoulder of another employee, you say, well, I suppose you could say that the regular employee was controlling the activity at the time of the loss. Second of all, was there any economic benefit being derived? No, because they're just merely observing. And if anything, one could make the argument that, well, in fact, we're kind of losing, so to speak, productivity because of the interchange between the student and the regular employer. And the third part is, are wages being paid? So we know in this particular case, wages are not being paid. So again, the powers that be, meaning the administrative law judges that address workers' compensation claims, will look at that control issue and the economic benefit. So again, it depends on the facts and circumstances of the situation. Now, the one thing that I would point out is that for situations, and this is noted on my handout at the very bottom, for situations where you have unpaid, when I say legitimately unpaid, meaning all parties understand that nobody is going to get wages, there are statutes that allow school districts and actually technical colleges to agree to be responsible for those workplace injuries in unpaid situations. And I'm not advocating one way or the other that colleges or school districts should take on that responsibility. But I'm sharing that information with you to know that there are ways to meet everybody's objectives. And what I mean by that is school districts and technical colleges want their students to get real life experience. You all want to ensure that as time passes you have a workforce, a knowledgeable workforce. So these statutes are a way of, again, meeting all those goals. So if it's an unpaid situation, the school districts and the technical colleges can agree to accept that workers' compensation exposure for unpaid situations.
follow-up question. If a student is hurt, if a student or an intern is hurt, can they be given a drug test?
If a student is hurt, then can they be given a drug test? And the purpose of the drug test presumably would be to see if they're under the influence. Okay. My initial reaction is that that would most likely occur in a youth apprenticeship situation. And I'm not an attorney, number one, okay? But if I were the employer, or if I were the school district, I would like to be able to have that ability to do a drug test. So if that is something that you would ordinarily do for an employee who's injured on the job, and they're 35 years old, and you say, well, it's just standard protocol that if somebody gets injured, we do a drug test, and you are essentially treating your youth apprenticeship individuals like your other employees, then I would build that into the training agreement, that everybody is put on notice. And again, these training agreements, I take the perspective of, whether they're 16, 17, or 18, if they're still in high school, I would want to make sure that the parents are aware of what could go on, when they're going to be gone, all the things that I've noted on my handout. I think it's important to have that flexibility, to have the drug test done. And I guess I would, defer to Susie in that regard in terms of youth apprenticeship programs. Do you ever see that requirement in training agreements?
I have not seen it at this point. However, our training agreement is set up by DWD, and it has a general statement in it about the student employee, the youth apprentice, following the policies and the regulations that are in place at the employer. And so oftentimes after we do the employee training or education training agreement, it's followed up with, this is our employee handbook, and going through some of the points of it. And so I haven't been involved with one where there was a drug test in the case of an injury. I have been involved in some where there's a drug test that qualifies employment. So if you want to be employed there, they drug test every employee. They drug test their youth apprentices as well. So I've been in those situations, and that has been fine up to this point. Everybody is aware of it beforehand and goes into it just like normal. I have not seen one where it's been only on an injured basis at this point.
The most common question that I get and we get in the Equal Rights Division about this issue is from parents who are angry because their child is being drug tested without their knowledge or permission. So that's why even though you don't have it in the agreements now, it's probably a good idea to put it in there so the parents know this might happen.
And again, that's why I stress it doesn't matter what kind of job shadowing or school to work experience you're talking about. You should have a written agreement, because you're going to end up, and you all know what angry parents are like. Those are like your worst nightmare in many cases. So again, this is all about taking care of these details before something bad happens, so that everybody's on the same page, so that somebody can't show up in your office and start banging their fist on the table saying, I didn't know that my kid was going to be drug tested. If I had known that, I would have never allowed. And it just escalates, and pretty soon the emotion takes over most everything. So I would say, though, if you're talking about a 16 or 17-year-old that's not in a youth apprenticeship program, definitely, if you want to have the ability to drug test, you've got to have that in the agreement. You've got to have the parents on notice, and the school district and the student, that is a real possibility. Because, when you get to those 16 and 17-year-olds, it can get a little dicey in terms of, their privacy being invaded.
And while we haven't directly mentioned this, in Janesville, we have had the parents sign the training agreement for the last 20 years, and it has been very effective. It has legal standing, and unfortunately there's been probably 2 terminations in the last 20 years, but the parent knew very well what the issue was and what they had agreed to, and they receive a copy of that document. And I believe it's the same with youth apprenticeship. The parents sign the form. So if you're looking to create one, Joy's a great resource, Susie's a great resource. You don't have to do it by yourself, but the parent signature or guardian signature is critical, and it's so seldom happens, but it's that one time, if you don't have it signed, that you'll have headaches for a long time. All right, Susie, how does the Youth Apprenticeship Program handle cell phones, texting, social networks? They didn't put on here low-riding jeans, but on the job. Could you tell us, is that misconduct, or what's the deal with that?
Sure, that's the same thing as what we've been talking about. What you expect for your regular employees is what you expect for your youth apprentices. And it should be upfront and forward with them at our beginning meeting when we set up that education training agreement. Everybody signs the agreement. There's a discussion around what the expectations are on the job site, and if it's no cell phones at all, if it's cell phones only in the break room, that should be discussed at that point. I think some of this comes along with the proprietary piece that we talked about before, that it should be very specific about what can be and can't be put on Facebook in some cases. It's not always clear to a 16-year-old where that line is. So being specific is helpful in this case to let them know what is expected, what is acceptable, and to make sure that when you're talking to them about it, their parents hear it as well.
Next question, is there any work that is completely excluded from child labor laws?
There is no work that is excluded from the hours limitations that apply in Wisconsin. The federal law, covers businesses of a certain size, but we have a state law which is pretty similar to the federal law. So we cover all businesses really in the hours. Now the work that minors do on family farms is about the only thing that is really off limits under federal law and state law.
So that a follow-up question to that would, do child labor law restrictions apply if a youth apprenticeship is working for a business owned by his or her parents?
Oh yeah, that's usually the context that this question comes up in. Yeah, they still apply. The only difference for a business that's owned by a parent is that, and this is obviously outside of youth apprenticeship, because the only difference in the law is that minors can work as young as 12 for a business their parent owns, when normally they could work at 14. So it lets them work a little younger if they're working for their parent's business. But that's too young for a youth apprenticeship, so that's not going to come into play.
And are work permits required for?
Work permits are required, even if your own child is coming to work for you.
Next question. And are there different rules for nonprofit as it relates to wage rates, work hours that would be different than a for-profit employer?
Wisconsin law has a few differences for nonprofits, and I mentioned one of them already, that minors can volunteer for nonprofits, charitable institutions, even government agencies. If they're under the age of 18, they can volunteer for those entities, where they couldn't volunteer for for-profit entities. The other distinction under Wisconsin law is that nonprofits don't have to pay overtime for the most part. And if you have a nonprofit you're wondering about, give me a call and I can discuss it with you. But generally, they don't have to pay overtime. Under state law, federal law still might require overtime payment for certain nonprofits.
If a 16-year-old applies for a work permit naming manufacturing as an occupation, will it be rejected unless it relates to an apprenticeship or a youth apprenticeship?
16-year-olds can work in manufacturing. It's under 16 when they can't work in manufacturing. So generally, we get a letter from the employer which shows what the duties will be. The permit officers look at that and see whether there's anything there that might be prohibited, and I often get calls on those issues. I've got this 16-year-old in the office. They say they're going to be working in a manufacturing environment and using saws. It's woodworking. I would tell them in that case not to issue it unless it is a student learner program of some sort. Youth apprentices don't have to get work permits under the law, but the youth apprenticeship program recommends that they do, but they are excluded from the work permit requirement. Other sorts of student learner programs still need to have work permits.
If I can add to that real quick, my understanding is if a student, and correct me if I'm wrong, please, if a youth apprentice is working in the youth apprenticeship capacity, they don't need the work permit because the education training agreement's on file. But if they're working, summer hours and they're not working within that youth apprenticeship construct, then they would need a work permit.
You bet, that's right.
Okay, so the question was, how is the screening process handled for youth apprenticeship students, and specifically around manufacturing? So what we do at a school level and a county-wide, district-wide level is ask students who are interested in youth apprenticeship to go through a process where they come to an information meeting, they complete an application packet with some general demographic information, a resume, and a cover letter explaining why they want to be part of the youth apprenticeship program. Most school districts then interview the students to let them know whether or not they're a candidate for that school district's youth apprenticeship program. So then we have a pool of candidates in that school's youth apprenticeship program. From that pool of candidates, if you have a job posting opening, we would let those students know and we would work with you to identify how you want to select students. So if you want to come to the schools and interview students, you could. If you wanted to come here and interview students, if you wanted students to come to you, I know some companies require testing for students before they can interview, and so some students have to go to the job site, do a test, then apply, go through the application process and the interview and get selected. So once they're selected in the school district's youth apprenticeship program, the next step would be what selection process you want to get the right person for your company.
And to go back to the question that was asked earlier in the open session, when we look at a timeline, there are specific things that students may apply for. So for instance, if they're a youth apprenticeship, a high school student, and they want to enroll in a course at Black Hawk Tech next fall, if they'd like the school district to pay for that class through youth apprenticeship, they need to meet a deadline of March 1st for the school district for fall enrollment. That means that those students would have identified an interest in January, February. We would have been in contact with Susie or our site coordinator, and we have site coordinators at every school. The student would be approved by the school board in March, which means then they'd be enrolled in instruction, related instruction in the fall, but you would be interviewing that student over that springtime, or those students over that springtime, so you could have them gainfully employed at the end of their term, which is June 9th this year. You'd be able to work them over the summer, through the next school year. They'd be taking courses related to the instruction that fall. They'd get approved again in October for the spring term, and that related instruction is paid for by school districts through youth options, which is different than youth apprenticeship, and it can be very confusing. But that is a state program, and students are eligible to earn up to 18 credits in their junior and or senior year, paid for by the school district if the school district doesn't offer that programming. So it's a way for you to, as Carrie said earlier, test drive students who really are interested in a career and find out the best ones, and we would hope all those students that are interested would be placed in those positions. Does that help?
With that, I know we mentioned this before, and Steve just mentioned it, that students can begin working after the school year wraps up their sophomore year. They can begin working that summer. Just as a point of clarification, they can work 450 hours, they can work 600 hours in their time. We do want to have at least 250 hours of their time to happen concurrently with classes. So 250 hours of their work experience should be kind of during the school year when they're in classes, so that they get that integration between the classroom and the work site.
One other resource available to everyone in this room and everyone in Rock County is a website called Inspire Rock County. And that website has been created in collaboration with Rock County 5.0. Employers can sign on to that website. They can become mentors to students, or they can identify themselves as someone interested in work-based learning. I know that Ron is here, and he's working with us with the fire service, the police in the Janesville area, and they're working with us to link to that website. You will be able to post openings that you're interested in filling on the website, and over the next year to 2 years, Rock County school districts are training staff and students how to use that website. So I'd really encourage you, if you're not familiar with the website, just go ahead and Google Inspire Rock County. It'll have an employer link, it'll have a student link, it'll have a parent link, and we're building that infrastructure over the next 2 years. Rock County 5.0 is committed to help offset some of the startup costs. that is going to be the direct link in the future between the employers and the schools. Because we all know occasionally you have an HR manager that leaves, so then when we call the office, they're not there anymore. This will be a site that's virtual and really, really will work well for all of the players involved. All right, Jim, we didn't practice this part, but you want to do follow-up closing remarks and the best takeaways we can send. And we do have an evaluation form we'd appreciate you to fill out. And if you have follow-up questions, Susie or I or Jim or Joy will certainly get back to you with those questions. But go ahead, Jim.
I guess the takeaway that I would hope you could leave here with is that just because you have prohibited equipment, places of employment, work that would otherwise be prohibited to minors, don't let that shut you out of this kind of an experience, because usually they can work fine. Minors can work in student learner programs at 16 or 17 if they're within one of these programs and getting the kind of instruction that we've all been talking about. So I don't just shut it out of hand, because it's a really valuable experience.
I would agree with Jim when, in the context of liability issues and workers' compensation, that you may hear from colleagues or insurance people, professionals, that, well, you shouldn't do this because of the liability, or you shouldn't do that because your premium's going to go up. Or, and I would say that, again, the common goals of all of these programs are for the students to get real life experience and for all of you to have a up-and-coming workforce that's well-trained and knowledgeable about your businesses. So what I would offer is don't let those comments get in the way. And what I mean by that is somebody may say to you that the sky is purple, but unless you can go check to see if the sky is purple, that may not be so. So if you have a concern related to liability or workers' compensation or exposures or things of that nature, you can always call me, number one. Your insurance policy actually is a great document to consult, and I know all of you read your insurance policies like everybody else. But just because, again, somebody says the sky is purple or you don't have coverage for X or for Y, that may not necessarily be the case. Now, I would also say that as a prospective participant in any of these programs, you do need to go in with your eyes wide open, because the reality is anytime you let anybody into your business, there's always a possibility somebody could get hurt. They could lose a tip of a finger. I worked with a manufacturer up in Woodville, and he said they had a youth apprenticeship person, and the mentor turned his back for a minute, and something came down and, cut the student on the arm and, needed medical attention and stitches. Those things certainly are going to happen, but they shouldn't prevent you from participating in those programs or any of these programs. And again, while it may seem like a no-brainer, I can't stress enough these written agreements, because it's making sure that the parents in particular are on the same page that will grease the skids for you or not. So that would be my closing.
So my closing, I think, would be that we have students in our high schools that are very interested in several different areas, including manufacturing, healthcare, agriculture, and we have fantastic instruction for them. We need work sites for them. So if you're interested in getting more information on this, I would be very interested in talking to you and finding out how feasible this is for your work site, because there really is benefits for having high school students out working with you, and we'd like to help you get that done.
So anything you can do to help us inform people of this information. There are, as we said earlier, there are a lot of myths that are not correct as it relates to child labor law, and we can help with those things. So help us reach out and find additional employers. We've got some great students that are looking to work, and we have manufacturers and service providers that are telling us that they need students, they need employees, and let's get those kids out there in a related area that we can make them pay for our retirement when we want to retire, and get them gainfully employed so they have an earning wage. That's what our hope is. I really appreciate the panel. Joy and Jim came down from Madison this morning, and Susie did a great job, so let's give them a round of applause.